If you've been following the Supreme Court even casually, you know that when the court speaks by a wide margin, especially an 8-to-1 order, it matters. Not because every justice suddenly agrees on gun policy, but because the court is signaling something important about how the law is supposed to be applied right now, and that's exactly what happened here. In a recent order decided by an 8-to-1 vote, the Supreme Court stepped in on a federal gun enforcement issue in a way that is already changing how lower courts, federal agencies, and regulators have to operate. This was not a full-length opinion, and it wasn't a sweeping rewrite of gun law. But make no mistake, orders like this can still shift enforcement in very real ways, especially when they come with that kind of margin. So today, we're going to break down what this order actually does, what it does not do, why the vote count matters, and how this affects federal gun enforcement going forward. This is not hype, and it's not legal advice. This is about understanding what just changed and why it matters. First, it's important to understand what kind of action this was. The Supreme Court issues different types of decisions. Full opinions resolve cases on the merits and often take months to write. Orders, on the other hand, are typically faster, narrower, and procedural. But that doesn't mean they're insignificant. In fact, orders often determine what the government is allowed to do right now, while bigger questions are still being litigated. In this case, the court intervened in how a federal gun-related rule or enforcement action is treated while the underlying legal fight continues. That alone tells us something important. The justices believed there was a serious enough legal issue that letting enforcement continue unchanged posed a problem. Now let's talk about the 8-to-1 vote, because that's critical. This was not a razor-thin, ideologically divided decision. When 8 justices agree on an order like this, it signals that the legal concern crosses typical partisan or philosophical lines on the court. It doesn't mean every justice agrees on the Second Amendment in general. It means they agree that something about how the federal government is enforcing or defending this rule raises red flags under current law. That matters for agencies like the ATF and the Department of Justice. Federal enforcement agencies rely heavily on lower courts giving them deference while cases move through the system. When the Supreme Court steps in early and says, in effect, pause, this isn't being handled correctly, that deference weakens. What this order does not do is suddenly legalize or ban anything nationwide. That's a key point that some headlines will get wrong. This is not a final ruling on constitutionality. It does not strike down a statute. It does not announce a new test or overturn precedent. What it does is change the legal environment federal enforcement operates in, sometimes immediately. Practically speaking, orders like this can limit how aggressively federal agencies enforce certain rules, force lower courts to reconsider injunctions, or require the government to justify its actions under stricter scrutiny. In the post-Bruen legal landscape, that scrutiny is already much higher than it used to be. And that's the broader context here. Since the Supreme Court clarified the historical tradition test for gun regulations, federal agencies have been on shakier ground when issuing rules that stretch statutory authority or rely on modern policy arguments. Courts are no longer supposed to defer automatically to agency interpretations when constitutional rights are involved. This order reinforces that reality. It signals that the court is paying close attention not just to gun laws themselves, but to how those laws are enforced, who is doing the enforcing, and whether agencies are staying within the authority Congress actually gave them. Another important point is how this affects lower courts. Federal district and appellate courts take cues from the Supreme Court, especially from orders with overwhelming margins. Judges now know that if they rubber stamp federal gun enforcement without carefully applying the correct legal standard, there's a real chance the Supreme Court will step in again. That has a chilling effect. Not on gun owners, but on overly aggressive enforcement. Agencies become more cautious. Government lawyers become more conservative in how they argue these cases. And regulators start thinking twice before pushing the limits of their authority. Now, let's address the dissent. The lone dissenting justice does matter, but not in the way some people think. A single dissent in an 8-to-1 order usually reflects a disagreement over timing, procedure, or judicial restraint. Not necessarily a belief that the federal government should have unchecked power. Lone dissents often signal caution, not ideological opposition. What matters more is that the dissent failed to persuade the other 8 justices. That tells us the majority viewed the legal issue as serious enough to override concerns about waiting or deferring to the lower courts. So what does this mean for gun owners right now? For most people, the immediate, day-to-day reality does not change overnight. You're not suddenly exempt from existing laws. You're not suddenly subject to new ones either. But behind the scenes, the balance of power shifts slightly away from federal agencies and back toward courts and constitutional limits. This also matters for future cases. When the Supreme Court shows it's willing to intervene early and decisively, it encourages more challenges, not frivolous ones, but serious, well-grounded legal challenges. It tells litigants that the court is not content to let questionable enforcement drag on for years before stepping in. And that's why waiting a few days to cover this actually makes sense. The real impact of orders like this becomes clearer as lower courts react, as agencies adjust their guidance, and as government attorneys recalibrate their arguments. Early coverage often gets the headlines wrong. Careful coverage gets the implications right. The bottom line is this: federal gun enforcement did not collapse, but it did just get more constrained. The Supreme Court reminded the government that enforcement power has limits, that agencies must stay within their lane, and that constitutional rights are not optional, even during ongoing litigation. This isn't the end of the story. It's a signal. And signals like this, especially when they come by an 8-to-1 vote, tend to shape what happens next far more than most people realize. As always, we'll continue tracking how this plays out in the lower courts and what it means for gun owners going forward. This is 2A Freedom, focused on facts, law, and constitutional reality, not clickbait or guesswork.